What can I say following an introduction like that? Maybe use an old line from Amherst. Perhaps you have the wrong Reverend Jackson in mind. I don't know. Thank you, some of you, for coming for the third time. I have to tell you, I've just been very touched by the reactions I've had from the students. I had a very packed talk this morning, and I'm touched by the people who stayed with me on it. I'd like to come again. I think the best compliment I could give you is that I'd just love to come again. But perhaps I'll see some of you in our James Wilson project and the Institute on the American Founding. Some of you may come to us as interns. And so I've left some pamphlets over there for people who may be interested in the James Wilson Institute. Some of you may be going on to law school. We'll see you. But anyway, even before that, we hope we may be able to see you. I'm tempted to share with you an item that my late friend Mike Ullman clipped from me from the Metropolitan section of the New York Times some years ago. Sketches of life in the city seen by the people who observe them. And one from years back read in this way. It said, "Dear Diary, it was midway during Act 3 of La Traviata at the New York City Opera. After witnessing Alfredo's confession of love, Violetta's rejection of the carefree life of Paris, their retreat to the country. But Giorgio's appeal to Violetta to release Alfredo for the benefit of his sister's prospects of marriage, Violetta's compliance, her pretended deceit, Alfredo's jealous rage, her reversal and illness, Giorgio's sympathy, the lovers' tragic reunion, and Violetta's death. After all of that, I heard the woman behind me say to her companion, 'The same thing happened to my girlfriend Gloria.'" So I want to draw on the same blending of the grand and prosaic in finishing this talk and bringing it to its culmination. I do have quite a lot packed in here. I may be tempted to use an old device of mine and compress this talk Hebraically by omitting the vowels. It could sound Welsh. Okay. But actually, stay with me. I've got a lot here. You've been so patient. I hope you'll stay with me. I've tried to time this to keep it in time, but I hope you'll stay with me. Here we go. Ephraim Bernstein, born in Poland, 1893, made his way to America, became a citizen in 1926. 25 years later, he was sojourning or living in Israel, and he voted in an election for the Knesset. But to vote in an election was to take up political rights that mark the highest levels of citizenship in the power to determine who forms the government. So under the laws of the United States at the time, taking up citizenship in that matter was taken as inconsistent with American citizenship. And so Bernstein lost his passport, and with that, his citizenship was revoked. He brought suit to contest the matter, and that suit made it all the way to the Supreme Court. The court actually came down on his side with a decision that was once sweeping in liberality and in principle deeply implausible. Justice Hugo Black, the most senior of liberal judges, wrote for a closely divided court. The question, he said, was whether Congress can, consistently with the 14th Amendment, enact a law stripping an American of his citizenship, which he's never voluntarily renounced. Black swept to the conclusion that Congress does not have any general power, express or implied, to take away an American citizen's citizenship without his assent. That is, for any reason at all. But as Justice Harlan pointed out in his dissent, in one of those rare dissents that just blows away the majority opinion, you wonder how anybody could assign onto that without embarrassment after reading Harlan's dissent. He pointed out that all of Black's references here to Congress amounted to a stylish evasion. All the Black citations were to declarations or judicial opinions early in the 19th century, and the point was that Congress or the federal government had nothing to do with dissolving citizenship. Because we were functioning then under what was called, in some places, the Jeffersonian theory of citizenship, that citizenship was conferred by the states. You became an American citizen as you acquired citizenship in the separate states. All that changed with the 14th Amendment, which overcame the decision in the Dred Scott case and provided there is indeed a ground of national citizenship for black people and for anyone else who is, quote, born or naturalized in the United States and subject to the jurisdiction of, a phrase that could become quite troublesome more recently. But just prior to the passage of the 14th Amendment, as Harlan pointed out, Congress exercised the very authority that the court suggested now that it should have recognized was entirely lacking. Congress passed in 1865 the Enrollment Act, which removed citizenship from people who deserted the Union armies. But even more critically, just a year earlier, both houses of Congress came together to pass the Wade-Davis bill, which asserted that every person who shall hereafter hold any office in the rebel service is hereby declared not a citizen of the United States. For who could have doubted the force of the point in principle? The men who held positions of leadership in the rebel government were people who had showed a wholehearted support for a project of dismantling or destroying an elected government through force of arms. Lincoln made the point to a visiting delegation of clergymen in Chicago that the two issues of slavery and rebellion were in point of principle the same. It was no accident that the same men who were willing to make slaves of other men were willing to act out a gesture of disrespect for an outcome of a free election. For both sides were rejecting that anchoring premise that all men are created equal, that the only rightful government over human beings depended on the consent of the governed. Men who were willing to take up arms to overturn a democratic election had shown that they were at odds with the deepest principle that defines the character of the American regime and the very grounds of the American citizenship. What it could it mean to say that one rejected the moral premises on which the American people founded their equal citizenship and their equality before the law, that one severed that deepest moral bond and yet claimed the right to live in America as a citizen? To say that is to say that there is no moral character to the American polity, no moral content to the terms on which we live together as a community. Citizenship then becomes a morally empty notion. It'd be rather like checking in and out of a hotel. We ought to remind ourselves that it's possible for people to be expelled even from the most natural unit of all, the family. People may do things so egregious that they could be left out of the will or severed from any connection to the rest of the family. To say that nothing may ever be done so wrong they can never impair the standing of a man as an American citizen is to say that there is no moral meaning at all to citizenship, because there is no moral meaning in the American regime itself. And yet this was precisely the understanding urged by Chief Justice Warren in the run-up to Ephraim versus Rusk. In Trope versus Dulles, Warren insisted that the Congress should not be able to deny citizenship to a man however reprehensible his conduct may be. In the same year, in Perez versus Brownell, he took this sentiment to a new level of heresy, for he declared that citizenship is man's basic right, for it is nothing less than the right to have rights. Now, how do we count the layers of moral inversion here? Citizenship becomes the basis of your right to have rights. To say that we have rights that derive solely from our citizenship is to fall into the heresy that we had no rights that flow to us by nature at the hands of our Creator before this republic was founded. It is to deny the understanding of the American founders that we begin with the rights that flow to every human being by nature, and we construct a constitution on that anchoring ground. It's never out of season to recall James Wilson's line that we did not bring forth this Constitution for the sake of inventing new rights, but for the sake of securing and enlarging those rights we already had by nature. On this point, James Wilson bore down even harder on William Blackstone, that venerable commentator on the English law. Blackstone had mentioned in his commentaries the right of personal security and personal liberty, not natural rights, as James Wilson expected him to say. Civil liberties of Englishmen, simply conferred by the positive law on Englishmen. Blackstone admitted, said Wilson, that these rights are founded in nature and reason, but he insisted that their establishment, as excellent as it is still human. Blackstone traced those liberties, as Justice Scalia and others conservatives have, to Magna Carta and the laws of England proceeding from that point. These natural rights are then converted into civil, simply civil, created under civil government. Civil privileges, it provided in lieu of natural liberties. And so Wilson said in a ringing phrase, if this view be a just view of things, then the consequence, undeniable and unavoidable, is that under civil government, the right of individuals to their private property, to their personal liberty, to their health, their reputation, to their life, flow from a, get this, human establishment and can be traced to no higher source. The connection between man and his natural rights is intercepted by the institution of civil society. The point not to be missed here is that Blackstone's position, finding the grounds of our rights, traceable to Magna Carta and the following expansion of English liberties, is precisely the understanding favored by many conservatives today. In Wilson's judgment, that was a mark of heresy, of not understanding those inescapable truths grounded in nature and not fully grasping, as the Declaration of Independence said, that this government found its ground, its rationale, its telos, its purpose in the securing of those natural rights. But what was the source of those rights? In the circles of the educated, it's simply a charming story to be taken seriously, to worry, as Wilson did, that the connection of the man and his rights would be intercepted by his relations to civil society, as though civil institutions were the source of those rights, rather than that creator who endowed us with rights. It would be regarded as laughable in the law schools or the colleges these days to talk about God bound up with the grounds of our rights. And yet, theism would offer quite as plausible account as any other, and would offer a far more plausible moral account of the law than one would spring from the universe reflecting no designing mind or purpose, a random or accidental happening, with no plan, revealing no moral purpose, disclosing any moral ends for human life. In his encyclical in 1881 on liberty, Pope Leo XIII said that it made no sense to impute property rights to animals, for cows and horses cannot impart a moral purpose to inanimate matter or to property. It makes sense to speak of rights only for those creatures of reason, those beings who can reason about the ground of their own well-being and the well-being of others, those moral agents who understand that they may not be able to claim a right to do a wrong, even in the name of their freedom. Only creatures of this kind understand that for every liberty, there's a version of license, that any liberty could be used for rightful or wrongful ends. But these rights came, as Thomas Reed and Leo XIII understood, from the Creator who gave us these creatures of reason, who alone could understand those laws of reason. For Reed and for John Adams, all of this made coherent sense. It was atheism that seemed to make no sense, nor offer any scheme of moral coherence. Then as now, our religious sentiments can involve different versions of revelation, which could lead us, as we know, to vexing disagreements, straining at times our civic life. And yet there is a deep credence, and there was a deep credence at the time, for natural theology, that could encompass some of the most critical things that Americans believed about the origins of the world and things divine without ensnaring us in disagreements over revelation. And this is what I think Andrew I think refers to in another name as civic theism. Civic theism. The ever-engaging Ronald Knox once observed that we had a tendency to name scientific laws for the men and women who discovered them. And so we would speak of Boyle's law on gases. But if it took a considerable mind to have discovered that law, as he said, it must have taken a considerable mind to have put it there in the first place. Some of the founders read David Hume in his histories or political commentaries, but they were not persuaded by his moral skepticism or his debunking of religion. Hume took the most familiar path among agnostics. He said that he was open to the proof of God's existence, but he wished to have more evidence. And Thomas Reid sort of restated Hume's position in this way, that if we had the experience of a series of trials, setting various worlds before us, showing the various effects in those worlds of degrees of wisdom, he might then be in a position to judge. But as Reid would point out, the issue cannot here turn on trials of experience. It involves things that we must be able to grasp in the first instance as a matter of common sense, as a self-evident truth, just as we grasp, as he said, that things cannot begin to exist nor undergo any change without a cause that has the power to produce that change. That every effect has a cause is a proposition so evident, said Reid, that there's not a man of common prudence who does not hold this opinion and rely upon it every day of his life. What was engaged here was something to be grasped in the same way, that there's no way of knowing through experience in 10,000 cases what could not have been shown already in the very first instance. Along this path, Reid cited John Locke's observation on the repugnancy to our conceptions that modes and accidents should subsist by themselves. Or to put it another way, there cannot be qualities of things without the things themselves. Or as Reid put it, figures cannot exist unless there is something to be figured, nor motion without something that is moved. Reid went on, from wise conduct we infer wisdom in the cause. From brave actions we infer courage. That is, we presume that actions or events are caused. And we take these actions as signs or reflections of the persons who caused them. I used to remark to my students that we met in lovely Fairweather Hall at Amherst. We sat in a building designed by the architects McKee, Mead, and White, and we think we can find evidence that all around us of the minds of the designers, even if we haven't met McKee, Mead, and White. And on this campus, you have ample evidence of the mind of Frederick Law Olmsted, even if you don't remember seeing a picture of him. As Reid observed then, thought is a sign of a thinking principle or mind. But how do we know that thought can be without a mind? If any man should say he knows this by experience, he deceives himself. It is impossible to have any experience of this. We have no immediate knowledge of a mind. The mind is an immediate object, is not an immediate object either of sense or of consciousness. We may therefore conclude that the necessary connection between thought and mind, or thinking being, is not learned by experiences. And so Reid thinks we must make our way to this recognition as one of those first principles we simply grasp, to wit, that from certain signs or indications in the effect, we may infer that it must have been intelligence, wisdom, or other intellectual or moral qualities in the cause. And so to restate the point, that design and intelligence in the cause may with certainty be inferred from marks or signs of it in the effect, or as St. Paul had it in Romans, that passage you'll remember in Romans 1, because that which may be known of God is manifest in them, for God hath showed it to them. For the invisible things of him from the creation of the world are clearly seen, being understood by the things that are made, even in his eternal power, David Hume wished to see a train of experiments or trials, but his rejoined, if the marks of wisdom seen in one world be no evidence of wisdom, the marks seen in 10,000 will give as little evidence unless in times past we perceived wisdom itself conjoined with the tokens of it. Or there was no way of knowing in 10,000 cases what would not have been known already in the first case, as we grasp that from certain signs or indications in the effect, we may infer that there must have been intelligence, wisdom, or other intellectual qualities in the cause. What was particularly striking about Reid's argument is this. He showed that Hume could not sustain this argument about the first cause in the universe without calling into question at the same time the grounds in which we infer the existence of anyone apart from ourselves. For the massive effects all around us, we have the plainest mind at work, he said. We may decorously put aside for a moment the question of whether that mind at work, that uncaused cause of the universe, is the one we've come to know as God, the Creator, who endowed us with rights, brought the Hebrews out of Egypt, and begot a Son who died on the cross. Putting that aside for a moment, there are things that reason alone can tell us of the mind that produced these powerful effects. As Thomas Reid says, first, it cannot be a material figure, for material is subject to decomposition. We must be dealing with a non-material cause of a material universe, something that will be with us enduringly. And thought cannot spring from inanimate matter. Chairs do not have thoughts. Thought and mind must be immaterial, nor can that thought be confined to any place. So as Spinoza remarked, Moses might have been engaging in a bit of dramaturgy as he went up into the mountain to receive the 10 Commandments, but as Spinoza remarked, God could have heard him just as well if he stayed on the plain. God was not suffering from declining auditory nerves, just as God the Father will not suffer prostate problems, right? I can't presume to say how atheists or agnostics will be struck with indifference, or struck as I am with awe, at the resounding fact of the Big Bang. At the very least, we won't have to concede that as special effects go, this was one neat trick. And the awesomeness surely had to be merited by the fact that with the Big Bang came the beginning of something strikingly new, namely, all of the laws of physics coming into being at the same time. As Thomas Reid wrote, this thing could not have sprung from a plurality of design. It can't come from a committee or from the coterie of those gods marked by Homer. What was manifest, said Reid, was the form and uniform contrivance of the universe. All appear under one government, subject to the same laws, and therefore there must be one lawgiver. We may recall here Augustine, with the same reasoning in the City of God, making a mockery of the stable of Roman gods. And he says, at a marriage, the god Eugonotus is brought in when a man and a woman are united in the yoke of marriage. The god Damodocus is employed to lead her home, domum ducere. The goddess Manturna is called in to see that she will remain there, manera, with her husband. The goddess Virginensis has come in to loosen the virgin girdle, and the father Subigus to subdue, subigere, and mother Prima to press, and the goddess Protunda to pierce, Protunder. And all of these gods are engaged before we even get to Venus and Priapus. And so as Augustine asks with marked wonder, why is the bridal chamber filled with a mob of divinities when the bridal escort retires? The lesson here is that the divine gift of reason may deliver us from this kind of gullibility and offer the grounds for recognizing some of the extravagant and spurious claims that are offered in the name of a lawgiver. The reach of that lawgiver was universal with the laws of nature. But was it conceivable that the author of those laws would have given us a universal law of physics, but somehow given us a different moral law for Paris and Atlantic City? Reed posed the point in the most compelling way. We see all about us the wondrous effects of a being who had the power to produce these effects. He surely had to be aware of the question of anyone facing the exercise of power, whether that power is going to be used for ends good or bad, rightful or wrongful. God the Creator had to be aware of this. And so it has been widely taken for granted that God, the Creator who brought forth his universe, brought forth also a moral law as objective and settled and universal in its reach. So when Abraham found himself negotiating with God over Sodom and Gomorrah, there didn't seem to be a trace of doubt about the principles of moral judgment that God would respect along with everyone else. Shall not the God of all the earth do right? Would he destroy the innocent with the wicked? Now, Abraham negotiated God down to 10 righteous, but apparently even they couldn't be found. But the principle has endured on the wrongness of killing or punishing the innocent. And so it's been taken for granted in our Christian Jewish heritage that it will support and reinforce the principles of moral judgment at every turn. Now, we could cite almost any one of the founders, and one who comes more readily to mind is George Washington in his farewell address. Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable support. And let us with caution, indulge the supposition that morality could be maintained without religion, or that national morality can prevail in the exclusion of religious principle. Now, that understanding had been deeply embedded in our public teaching since well before the founding. And in that case, how do we account for the bewilderment of defenders of religion in our own day who regarded it as unthinkable that we should refuse to regard Satanism as a legitimate religion in this country, so long as people claim to hold this persuasion earnestly, sincerely? The test of sincerity has taken on an ascendant importance precisely because it's been thought too vexing, too likely to foster religious wars if we recognize a moral ground for judging certain religious claims as illegitimate. Members of the Church of the Latter-day Saints know quite well that the national government suffered no skepticism of moral judgment when it insisted on denying the moral and legal acceptance of polygamy. And in Reynolds versus United States, where the Supreme Court came down forcefully against polygamy, Chief Justice White made it clear that there's no way that the law would stand back if a widow were burned on the funeral pyre of her husband, even if this ritual was acted out under the banner of religious belief and acted out sincerely. But in our own time, there's been a curious turn away from the conviction that the law has access to standards of reason that may indeed supply the grounds of judgment in relation to religion, along with everything else. The lawyers and judges retreat to tests of sincerity to ward off claims that are pretext. But that test of sincerity is simply a way of smuggling in a moral judgment from the back door. For after all, the ministers of the Church of the Flying Spaghetti Monster with collars on their heads, why do you need sincerity for a religion? Why can't we have an insincere religion if it's simply a matter of our beliefs and our beliefs are not to be tested? And that retreat from the ground of moral judgment has gone hand in hand with a tendency at times to convert religious convictions into matters merely of belief, which have no claim to be respected as truth for anyone who doesn't share them. And so a teacher refuses to use a feminine pronoun for male recently transgendered into female will appeal to his sincerity in holding to a long-established understanding that God made us male and female. But it must be an enduring mystery as to why a court could more readily credit the components of that claim, that God created us this way, that one stands on plausible ground for believing that God did it. Why is it easier to credit those claims as opposed to recognizing the objective, inescapable truth of the matter? This is how we must be constituted in nature as males and females, if human beings as a species can reproduce themselves and survive? Why isn't the objective truth of this matter as more instantly available and understandable? The scheme of appealing merely to beliefs is eminently implausible, and yet our litigants have been tutored to speak those lines. And so Mr. Green, the owner of Hobby Lobby craft stores, professed his earnest belief that human life begins at conception, his earnest belief. And for that reason, he has no willingness as an employer to offer the benefit of covering abortion and contraception in medical plans. He has an earnest belief that life begins at conception. It's a truth confirmed anew and ever more deeply in every textbook of embryology. He offers this as his earnest belief. It's an established truth that human life begins with the uniting of a male and female gamete to produce a new entity with a genetic identity of its own, not exactly the same as the parents. There's no betrayal of coherence on the part of people who think that the wrong of transgenderism or abortion or same-sex marriage finds its ground in the nature established by the authors of the laws of nature. Yet the religious in this country know at the same time that the sense of how we are constituted as males and females, or the human standing of the child in the womb, can be confirmed on grounds of evidence and reason that are accessible and understandable even to people without religious beliefs. The Catholic Church, as I pointed out, worked for years simply on the moral reasoning of that. Without appeals to faith or reason, they simply made the case, drawn from embryology and principled reasoning. There's no ground or principle on which to deny the human standing of the child in the womb that would not apply to many people walking outside the womb. That's not an appeal to belief or faith. It's an appeal to the evidence of embryology woven with principled reasoning, all of which gives rise to this problem, testing the coherence of our schemes of religious exemptions. Let's imagine a businessman who's not Catholic. Do you have a question? Okay, I thought you were looking at your phone for something. Let us imagine a businessman who's not Catholic and professes no question at all. He professes no religious belief at all. Yet he reasons about abortion in the same manner as the church, drawing on the evidence of the child in the womb and his common sense moral reasoning. Now, why would the Catholic businessman claim an exemption under the laws enjoining him to support abortion, while this other businessman, who reasons about the matter precisely as the church does, but with no religious reflexes, why this man has no standing to claim that exemption? I take this problem to remind us that our religious tradition does not have its principal bearing on our law as a ground on which to exempt us from the obligations that are imposed with justification on other citizens. Our Jewish and Christian tradition touches the matter at the very root in the way caught by Lincoln when he said that no one made in the graven image was sent into this world to be imbruted, to be treated as a nothing whose interests and injuries do not count. Or Justice McLean, as I cited before, in his dissenting opinion in the Dred Scott case, when he leaned in and said, "You may think that black man is chattel, but he's a creature made in the impress of his maker. He's amenable to the laws of God and man, and he is destined to an endless existence. He has a soul that will not decompose when his material existence comes to his end." I have many liberal colleagues at Amherst with vast sympathies for people all over the world, but even they have to agree. They cannot give the same account of the wrongness of slavery, of the wrongness of genocide that McLean was in a position to give. Our religious tradition establishes there's something that does not flow through a syllogism and runs beyond anything given to us in Greek philosophy. It establishes why that human person, as John Paul II had it, had a claim to our respect as a rights-bearing being. With that premise in place, all of the rights that flow by nature come into play, as the life not to have one's life taken, one's property confiscated or seized in a lawless way, one's liberty curtailed without justification. All of those rights in our Constitution, finding their source in natural rights, come into play now. And it will be necessary it will not be necessary to say in all cases where our liberty is being restricted in an unwarranted way, that the measures of the law somehow interfere with our freedom to worship. Mr. Green, the owner of the Hobby Lobby stores, was not being denied his freedom to worship and to live his own life in accord with Christian principles. He was having his property commandeered, not through a scheme of taxation that applies to everyone else, but in a way that settles upon him alone the obligation to supply at his own private expense what the government regards as a benefit commanded by public authority. And when we seek to vindicate the constitutional rights of Mr. Green on this basis, what I would submit to you is that we are not invoking a ground of right that is in any way morally diminished from the right he would claim to exercise his religion. For what we are saying that he's a rights-bearing being, and to use an old phrase, attention must be paid. Or to put it another way, there is nothing trivial about these kinds of rights, because there is nothing trivial about the persons who bear them. In the Dobbs case, Justice Alito carefully framed an argument about the child in the womb that did not depend at all on religious faith. He took note of the curious, facile arguments. The offspring in the womb does not count yet as a person protected by the law because it is lacking in consciousness or self-awareness or an ability to reason. But as Alito pointed out, by this logic, it would be an open question as to whether even born individuals, including young children, or those affected with certain developmental or medical conditions, would merit standing as persons. He also insisted that, raised the question of why it would be justified to protect the fetus after the point of viability, and not quite as justified to protect the same small human being before viability. For we're dealing, after all, with the same entity. It's the same human being. And no person loses the protection of the law and simply becomes weaker in needing the protection of others. Alito said enough in these economical passages to show us that there was no defensible ground for denying the human standing of that child in the womb. His argument bore its own force, and with that, its dynamism. Nothing in the substantive argument itself would have barred him from pronouncing the conclusion that that offspring in the womb has never been anything other than human from its first moments. And that would have made a profound difference for the course and of our character of our politics in the last 2 years. In the first place, to recognize the child in the womb as one of those human lives protected under the law, the 14th Amendment would kick in. And so the federal courts can intervene when the blue states withdraw the protection of the law from a whole class of human beings. There would have been a profound difference also with the question of chemical abortion, mifepristone. The case was confined to the question, had the FDA been fastidious enough in determining that this mifepristone was safe for the women who took it? But if there had been a recognition of the unborn child as a human being, there would have been a second person in the picture. We'd have the person whose extinction it was the purpose of the drug to accomplish. So much was riding on this decision and the willingness of the court to pronounce on the question of moral substance that was truly at the heart of the case. That what was it that was being destroyed in these surgeries and abortion? To draw a word from James Lewis, we might ask, what intercepted the court from drawing that simple, momentous conclusion that flowed so readily from Justice Alito's opinion? What got in the way? What deflected the flowing argument of Justice Alito on its way to the payoff conclusion? What got in the way was a theory. The center of the problem for conservative judges was a theory about the rightful and wrongful reach of the judges, quite apart from the moral substance of the case. As the argument ran in its principal iteration, no right to abortion was mentioned in the Constitution, and so no federal judge was in a position to proclaim any new rights of that kind emanating from the Constitution. But marriage was nowhere mentioned in the Constitution. When the court struck down the laws that barred interracial marriage in 1967 and proclaimed a new right to marry. And as my colleague Gerard Bradley has pointed out, abortion had been very much the business of the federal government long before Roe v. Wade. There was the matter of barring abortions in military hospitals, in diplomatic outposts overseas, or in the territories, or the District of Columbia. But running far deeper here for conservatives was confusion about the kinds of objective truths that were put beyond the permit of unelected judges. And so my own dear late friend, Antonin Scalia, famously said in his dissent in Planned Parenthood versus Casey, the whole argument of abortion is whether that offspring in the womb is a human life. There's, of course, no way to determine that as a legal matter. It is a value judgment. Well, value judgment is a term that came into being with Max Weber and Nietzsche, when people started losing their confidence about speaking of moral truths, and things would have moral value as we valued them. The question is, Harry Jaffa once made the place, whether the black man was a human, to be regarded as a human being, was not a value judgment. It did not depend on how much it valued us, how much value it had for us to regard him as a human being. And it made just as little sense in estimating the standing of the child in the womb. How much value did it mean for you to recognize, as though there's no objective truth associated with this matter? And yet, this is just where the matter of abortion stood in the votes that counted up in the Dobbs case, that the question at the heart of the case would be converted into a mere value judgment. Nowhere was this caught as precisely as in the concurrence written by Justice Kavanaugh, where he wrote that many pro-life advocates forcefully argue that a fetus is a human life. Forcefully argue? As though there's no long settled empirical truth on this matter, found in all the textbooks on embryology? In other words, in this mode of conservative jurisprudence, the judges must affect not to know the plainest objective truth that bears on the judgment here. That judgment is reserved perhaps to people in elective office, which is to say, conservative jurisprudence in this light would take as its beginning point on the matter of its abortion by its willingness, as I've said, to live affably with a radical falsehood. And that concurrence by Justice Kavanaugh is the telling sign that the opinion in the Dobbs case left the human standing of the child in the womb to the value judgments reached by people in the states. That's all. If that were not the hard truth of the matter, Justice Kavanaugh could have not written those lines. And that was apparently the price that Justice Alito had to pay to get that fifth vote to overturn Roe v. Wade. A price that should not have been paid, in my estimate. And this brings me now, as I move to my conclusion. At the same time, this unaccountable outcome may reveal the key to the most consoling solution to the problem that I would leave with you. We've seen Catholic and Protestant judges put on the defensive over the years as to whether the serious teachings of their religion would affect or shape their jurisprudence. Many have seriously pondered the problem and come to the judgment that their religion happily will not affect their understanding of the law. But regrettably, that sense of surety was won for them through the persuasion that the conservative judge would not let his moral judgments seep into the law through artfully disguised value judgments. And yet a solution is at hand that yields, I would submit to you, a better surety and serenity. It would begin with a religious judge recognizing that it does not require revelation to understand those rights that flow to human beings by nature, as opposed to creatures that cannot reason over matters of right and wrong, weigh the terms of a contract, and tender a knowing consent. We have, in other words, the natural law still with us to reason over these things without appealing at every turn to revelation. Judges need not be bashful in holding back their religious convictions when they see that those convictions give them a more moving way of explaining why that two-legged figure who conjugates verbs is a rights-bearing being. They can say without embarrassment that some of us still hold to this ancient sentiment that this human being, even in a sorry state, was made in the image of something higher. But the more decisive epiphany may come for the Catholic judge when he comes to see that the Church has been the main sanctuary preserving the natural law, while the currents of relativism have eroded all the institutions around us, including the schools of philosophy. The Church, holding strong, gave it a chance to catch our breath. It brought time for Protestants and Jews to have a second wind, drawing from their own traditions and gaining anew their own confidence in affirming their own teachings of natural law, as we are seeing now growing. That natural law would have the advantage now, the advantage of rescuing Christian and Jewish judges from the soft fallacy. They are compelled to fall back on value judgments when they're faced with the need to reason about substantive moral judgments. The American founders of the caliber of John Marshall, James Wilson, did not think there was anything in the classic teaching of law, or anything in the Constitution they had made, that barred them from moving in their opinions beyond the text of the Constitution to those anchoring objective truths that were there before the Constitution. The truths that would be there, still be there now, as I said, even if there were no Constitution. And if that much is clear, there should be nothing in any theory of conservative jurisprudence that bars that appeal to objective truths beyond the text, especially when, as Marshall, Wilson, and Alexander Hamilton understood, those truths furnished the ground of explaining the coherence of their judgments. For the Catholic, the Protestant, the Jewish judges, who are beset now with worry and uneasy, needing a kind of new guide for the perplexed, the salving difference may come as they recall that the natural law has been the gift of our religious heritage. It's the gift that now may settle the mind and restore the confidence that we are, as we are, and as we will ever be, constituted by the authors of our nature, constituted with that gift to reason and to judge. Thanks very much.